Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing termination with cause and whether or not you are entitled to anything from your former boss, or if having been fired with a stated cause, you are simply out of luck. And what we're going to see is that even though from the academic perspective and from the pure legal perspective, you might be denied termination pay and severance pay, and this might be stated in your contract also. This is only the beginning of the legal analysis that intrepid lawyers will undertake, because all too often there is far more that goes behind a termination with cause, because it is a single aspect in the employment scenario that is being dealt with. And until you look at all the aspects involved in the individual's prior employment, not just the final moments of their termination, but the entirety of their employment, that you are able to discern whether or not the employee who has recently been fired is or is not entitled to something further than what they've been paid to date, and whether or not the denial of any further payment from their former boss is legally sufficient. And when you really think about it, at least from a lawyer's perspective, when you're pursuing these matters, there really isn't much to lose, and there is a lot to potentially gain. I'm not saying that you're going to, in every circumstance, find money that's owed to the fired employee who's been fired for cause, or what is claimed by their former boss to be cause, because that's a difficult test to prove oftentimes. But beyond that, there could very well be far more that is due to that employee, depending upon the circumstances, depending upon the jurisdiction within which they're working, and whether or not the compensation and pay that was being provided to that employee during the course of their employment was in fact correctly undertaken in accordance with the applicable employment standards legislation. Because all too often, employment standards legislation is not being correctly followed. It's a difficult process, and what employers are consistently trying to do is to pay the minimum. And even though they think they're paying the minimum, when they do that, they all too often fall into the all too common trap of paying the minimums based on another jurisdiction's laws, and thereby not following the applicable employment standards legislation. But going back to the aspect of there's nothing to lose with pursuing these matters. From a lawyer's perspective, an employee who has been purportedly terminated with cause is really being offered next to nothing. So there's no loss that's going to be incurred by looking into this, by pursuing it beyond what has already occurred. Conversely, take for example an individual who's been terminated without cause and has been offered up a termination package of, let us say, $100,000, $125,000. Having seen those packages, there is incredible incentive on those individuals to take that package, because to litigate the matter, you would only be entitled to the statutory amount that is required to be paid within a specific time frame. So taking, for example, the amount of $125,000 package, presumably $35,000 or $40,000 are statutorily mandated. The remaining money is someone in contention and is being offered up. And all too often, those individuals are not willing to jeopardize or, more importantly, delay the process of getting that money. Even though, under careful analysis of the situation, not only from the technicalities of employment standards legislation, but also review of common law and court precedent, those scenarios oftentimes have revealed that that individual could very well be entitled to $200,000, $225,000 by way of example. Nevertheless, you're risking the entire amount beyond the statutory amount of $35,000 to $40,000. And even if you're agreeable with the lawyer, there is delay in attaining that money. So that even though you get the initial amount, the other $70,000, $80,000 is put on hold for a considerable period of time. It can be years if the appropriate strategy is not implemented. And oftentimes with the financial demands on individuals, especially after they've lost their job, holding off for 6 months, a year, 2 years, or even more to attain what is rightfully due, what is illegally due to the individual, is far too much. So when we look at a situation where somebody has been terminated with cause, in those scenarios, there's nothing that's being offered up. They've simply been shown the door and told that termination pay in lieu of notice is not coming, severance pay is not coming, there's no release to be signed, no other arrangement that needs to be negotiated, no settlement that needs to be put in place. That individual is simply out of luck. And there's nothing in the way of money that is being jeopardized or delayed unless they take action. As such, somebody who has been terminated with cause and fired from their job, whether the cause is legitimate or not, really is in a position that they should be looking at what the scenarios are, what other aspects of the employment arrangement are at issue, and whether or not there is some basis to challenge the situation legally. Because if the situation allows for itself and the investigation shows weaknesses in the employer's theories, in the employer's arguments, as well as if it shows that there were inconsistencies in payroll, both in the practice and in the application, such that employment standards legislation was not conformed to, which is a very common practice, given that payroll is a much maligned area where not much effort by legal professionals is put in, and similarly accounting professionals. There is the potential for considerable amounts of money being at issue. And given that the risk is not really a risk, it's more of a question as to whether or not one is going to raise the matter with the right legal counsel, have that legal counsel explore the situation, and proceed therefrom. Because you're already out of a job, you're not receiving termination pay in lieu of notice, you're not receiving severance pay, and you might well have lost out on other payments that were properly due to you because your former employer was not following the law. And the standards for the employer are very high. The expectations from the legislation and from the courts are very high. But they would much rather have you simply move on, accept their arguments, and not look further into the situation. But what is the risk to yourself, especially where the legal counsel that you engage is willing to, at least at a minimum, undertake an initial investigation without cost to yourself, because there is the all too common belief that there are mistakes that are all too common, all too frequent among employers, especially in Canadian jurisdictions, and most especially as we're seeing today ourselves in the province of Alberta. But that is our own position. And that is something that you as an employee need to be considering, having lost your job, been fired purportedly with cause, a term that is very legalistic, but is very difficult to establish on the part of the employer. But nevertheless, having read stuff on the internet, having talked to other people, having an honest but guilty conscience, you might well think there's nothing much you can do. But in those circumstances, take a step back and ask yourself, should you not at least speak with one or more lawyers, engage them, set out your position, let them review your materials, as much material, as much information as possible, to ascertain whether or not what your former boss was saying is correct. And if not, is there a legal strategy that's available to yourselves to pursue this in a manner that's advantageous to yourself, especially given the fact that many lawyers will undertake these matters on a contingency basis. And they're only going to take these matters on a contingency basis if they solidly believe that there is something to be pursued. Lawyers are business people at the end of the day and are not going to pursue something simply because they feel bad for you or otherwise. They're going to put their time and effort into it because they see something that's worthwhile fighting, and it's going to be justified, and they're going to get paid for it. And that is why they pursue it. That is the rationale you have to understand the lawyer is operating from. So you need to look at it from your own perspective and see if this is worthwhile pursuing. If you want to take your lumps and not pursue it, that's fine also. But if you're serious about it and you feel whether you've been unjustly treated or you simply want to have that confidence going forward that you've at least looked at the situation and you're not walking away from money that's properly due to yourself, then even when you've been terminated with cause, as your former boss says, take a look at it with a knowledgeable lawyer and see if there are any viable legal angles to pursue. And if there are viable legal angles, seriously consider them. Because when it starts going, you're going to see there's oftentimes a lot more to it. And if there's a lot more to it, what's going to be your former boss's original position could very well all fall apart upon itself. And that is only going to be to your advantage. Thank you.